John?
Thank you, Mary. As Mary said, I'm corporate counsel at Alerus, and I think many of you probably know that not only are we a bank, but we offer retirement and health and welfare services to employers across the country. Currently, we service about 7,000 retirement plans and about 3,000 health and welfare plans. Our health and welfare group handles all types of employer benefits, including FSAs, HSAs, HRAs, parking and transit programs, VIBAs, COBRA administration, and payroll. When things get complicated, for example, in this current environment, that's when we bring in the law firm of Heitzman and Wold. And so we're lucky to have Darcy Heitzman with us this morning. Darcy's going to focus on the health and welfare side. If you are interested in issues affecting retirement plans, we have a separate webinar set for this afternoon at 2 p.m. Central. You should have received an invite for that. If for some reason you didn't, contact your Alerus representative and they'll get you access to that webinar this afternoon. So I think a lot of you know Darcy. She's an attorney and a frequent speaker on employee benefit issues. She's graciously agreed this morning to share her expertise with us. And with that, Darcy, the floor is yours.
Great. Thank you, John. Good morning, everybody. I was thinking about this on the drive-in and thought, well, this has some degree of normalcy. We're all listening to a webinar. But then I thought about the topic and no, we're back to not normal. So the title for this morning is really COVID-19's impact on benefits and programs. So the impact is really on the employer. And so whether you in the audience are employers yourself, trying to deal with these issues, your brokers or consultants, you know, whatever role you play in this part of the industry, keep that in mind that this is focused on the employer in its role as an employer. So here we go, and my little guy has rain, and I think it should have been snow because I drove in full snow today. But we are in April, and so I thought April showers bring May flowers and was trying to think positive here. So let's think about this. It's raining legislation and guidance. I've been practicing for a really long time, and I certainly don't remember this type of just being bombarded. We had the Families First Coronavirus Response Act. And I don't know if it's FIFI-CRA or FIF-CRA or what, but it's FF-CRA. It was signed into law, enacted on March 18th, 2020. It was effective generally on April 1st, 2020. No April Fool's joke there at all, even though a lot of information was talking about April 2nd. It was April 1st. Then we had some what we call sub-regulatory guidance. And sub-regulatory guidance is where one of the agencies involved comes out with a notice or FAQs, something on that order to help people understand what's going on. That was on Friday, March 20th. So here we have FF-CRA enacted on the 18th. We had guidance on the 20th. Think about how fast that happened. And it was Treasury and the Department of Labor. They issued IR 2020-57. It gave some significant direction about the tax credit that was going to be available to employers. It at least introduced the concept that there might be an exemption for certain small businesses. And it also provided a 30-day non-enforcement position, provided the employer was exercising reasonable and making good faith efforts. So, and that made sense because here we were, March 18th, it's signed into law, it's going to be effective April 1, and how the heck are we supposed to get all of that ready to go by April 1? So that was very welcomed. Then we had the Coronavirus Aid, Relief, and Economic Security Act, CARES Act. At least they came up with a good acronym on that one. It was signed into law, enacted on March 27th, 2020, so still before the April 1 date for FF-CRA. And there were a number of technical corrections that needed to be made with FF-CRA, and then there were also some new areas of need. So that legislation addressed both those topics. Then we had more sub-regulatory guidance. We had some FAQs, frequently asked questions, that were issued by the IRS on March 31st, still before April 1st, 2020. So the day before, you could actually get some guidance on what you were supposed to be doing the next day. And then actually on the day that we were supposed to start all this, we got Department of Labor temporary regulations. And those are of a higher level of guidance. Those are actually not considered sub-regulatory guidance. Those are considered real guidance. And I say that kind of tongue-in-cheek. We're very, very happy that that all came out. But it made it very difficult for all of us to try and figure out how to comply with this in a timely fashion. And many of us out in this neck of the woods are very conservative and compliance-oriented, and it has been kind of a nightmare. So today, we're going to focus on the employer-sponsored group health plans. Okay, think about that. That's stuff that's already in place, basically, that an employer has been doing, and how do these pieces of legislation impact that? Then we'll also be talking about the emergency paid sick leave requirements and the expanded FMLA. And if you just take a moment to think about those two, those are two federally required paid leave programs, and the requirement is placed on the employer. That is absolutely unprecedented. So we are definitely operating in some new territory, which is kind of exciting, but then again, we have to do it, which isn't so exciting. So we're going to talk about both of those areas this morning. So let's focus first on employer-sponsored group health plans. As I mentioned, these are things that employers pretty much already have in place, and they're operating, and they've been in place and operate completely without regard to COVID-19. But now these pieces of legislation impact how those plans operate, what they need to do. And so we need to take a look at how those new pieces of legislation do impact our programs, not only because we need to know what those programs need to provide, but we have a lot of compliance aspects that we need to be aware of. So let's talk about a couple of these provisions. First of all, we've got several statutory provisions that address issues related to employer-sponsored group health plans, kind of like our big, major, traditional, major medical coverage types of things. We have the COVID-19 testing and vaccines topic. We have the treatment of telehealth. And we also have some revised over-the-counter requirements and a new category of reimbursable expenses. So these are all things that these pieces of legislation have introduced and are going to impact the way we run our group health plans. So what do we mean by this? How does this really come into play? Well, first of all, it was introduced under FFCRA, and then it was revised. It was one of the areas that needed some technical correction, some technical help under the CARES Act. And so what it does is it requires group health plans and insurance carriers to cover without cost sharing to the individual the cost of diagnostic testing to detect and diagnose COVID-19. So it's the stuff that relates to testing to determine if a person has COVID-19. Makes perfect sense. We need to, we want to encourage that to be covered. We want to encourage people to go get that testing. It lists different sources of products that might fall within that category, and it also is drafted in a way that anticipates new products. So it really was trying to kind of take the situation and draft language that was going to really hit the mark in terms of what that legislation was supposed to accomplish. It also took the financial equation out of the question with respect to the individual, because it addresses the cost as it relates between the group health plan and the insurance carrier, but it has that official ironclad statement that it is at no cost to the individual. So those were all welcome. it made, it kind of set the ground rules, and there wasn't a whole lot of trying to wiggle out of an obligation there. But really the most significant part of all of this is that qualifying coronavirus preventive service was identified specifically as a preventive care benefit under the Affordable Care Act. Now, this is important because if we think about our normal group health plan coverages, we kind of got into the practice of saying, oh, that's preventive care, that's covered, first dollar coverage, no deductible applied. Okay, we got comfortable with kind of just spitting all that out. Well, this makes it clear that the qualifying coronavirus preventive service is one of those preventive care benefits under ACA. So we know how it's going to be handled, provided we know what it is. So they also gave us a definition of that. It's an item, service, or immunization that is intended to prevent or mitigate COVID-19 and otherwise meets the preventive care requirements of ACA. So again, we have this language intended to prevent or mitigate that's very broad and could include a lot of things, including things that we don't know about today but we'll know about tomorrow. So it was drafted to again, anticipate what's coming down the road. And then it pulled in and otherwise meets the preventive care requirements under the ACA. And that was incredibly important because if you think about the way they work right now, if a new preventive care benefit came out of the task forces, one of the task forces that recommends today, okay, April 9th, 2020, okay, it would be finally incorporated into our group health plans as a preventive care benefit covered first dollar coverage, no deductible, if we're a calendar year, on January 1st, 2022. Way too long a time frame. So under the legislation, under the CARES Act, there's an accelerated 15-day effective date. So we have one of these preventive services. It comes online. It otherwise meets the preventive care requirements under ACA, and we are going to have that considered a covered preventive care benefit for purposes of ACA 15 days later. Amazing, amazing. So that's good. Okay, so what are some other things that we need to be aware of with respect to the COVID-19 testing? Plans, group health plans, employer-sponsored group health plans are not required to go beyond the testing and beyond the preventive care, coverage, the limitation or the mitigation. Okay, but right away we had some plans that wanted to go beyond that, and this primarily came from the West Coast, and out of our office we worked with a number of third-party administrators in the Washington State area, and you may recall that they were a hot spot early on, and what they wanted to do, the plans wanted to do, was cover more than testing and include certain parts of treatment, whether it was hospitalization, different parts of the treatment, and the question was, well, can we do that? And you might think, well, of course you can do that. But it wasn't quite that easy, and it took some IRS sub-regulatory guidance coming out on March 11th, 2020 to make it clear that a health plan could go beyond just testing and include treatment, and that would not impact its status as an HDHP. And remember, the importance of the HDHP status is because that HDHP status is what allows people to make their HSA contributions. So it was really important that you weren't doing something that seemed really, really proactive and generous, and in turn, creating a problem for people that were making HSA contributions. So early on, we had that kind of a response from the federal government. Now, there were issues of going beyond just testing and the preventive care benefit aspect. And if you were insured, of course, you had to look at your insurance policy and was your insurance carrier going to allow that to happen? Not that long ago, like within the past 10 days, we had at least one insurance carrier that I'm aware of that sent out a notice saying, we are not going beyond. Okay. But then just recently we had the Minnesota governor request insurance carriers that covered people in Minnesota to go beyond and to actually include the provision of certain treatment remedies and services. So this is a fluid area. And so first of all, if you have an insured plan, be aware of what the carrier, what the position of the carrier is, and take a look at what state you're dealing with. If you are dealing with Minnesota, we have an idea of what might be going on, but if you are dealing with employees that are located in Wisconsin, Iowa, North Dakota, South Dakota, any other state, we need to be aware of what's going on there as well from an insured standpoint. Now, what if the plan is self-insured? Okay, that seems to be the area where the plan has the most flexibility. They should be kind of able to do whatever the heck they want, but they need to be careful as well. As I mentioned, thankfully we have the IRS information above about testing and treatment doesn't negatively impact HDHP status, but we do still have many self-insured plans have stop-loss carriers that protect the employer's general assets. We need to make sure that they understand what's going on as well. And obviously, in both of those cases, the people covered by the plan need to know what's going on. Now, all of this likely requires a plan amendment. Look at the plan language, okay? If it's different than what you want to do or what you need to do, we need to look at plan amendment. But more importantly, we need to be looking and making sure that the people covered by these programs understand that these different and sometimes very valuable expanded benefits are available to them. So moving on to the next one, telehealth. This is another really interesting one because telehealth and the way it kind of intersects with high deductible health plans and HSA eligibility. The ability to make HSA contributions has been around for a while, so it's kind of my pre-existing condition here. And the question is, if you provide telehealth and then the benefits under that telehealth, like the visits, are charged at less than fair market value, before the deductible on the high deductible health plan has been met, we have a problem because you are putting into jeopardy that HDHP status, and that in turn puts into jeopardy the ability of people to make HSA contributions. Okay, so with this legislation and the coronavirus situation, we have legislation, the CARES Act, that says telehealth is going to be allowed, and it's not going to challenge or put into jeopardy the HDHP status. People can still make their HSA contributions. And the telehealth involved here is not limited to the coronavirus. Okay, it's telehealth nuts to bolts, which is great. Okay, but it's temporary, and it only applies with respect to plan years beginning on or before December 31st, 2021. So it is temporary in nature, so keep that in mind. If you're going to expand and allow telehealth, then you are going to want to make sure that it's clear that it's temporary. Now, something else that needs to be clear here is that the legislative kind of recognition or okay on telehealth does not change ERISA or the Affordable Care Act rules regarding standalone group health plans. So that means in a nutshell that telehealth is going to have to be made part of or integrated with a group health plan that meets the ACA, the Affordable Care Act mandates, because the telehealth on its own as a standalone will not meet those mandates. And when we talk about the ERISA requirements, it means that it's going to have to be reflected in the written plan document. It's going to have an SPD or reflected in an existing SPD of another plan. COBRA is going to apply. The claims procedures requirements of ERISA are going to apply. I mean, it doesn't change any of that, but it does allow the telehealth to be offered, to be included, and it's not going to jeopardize the HDHP status or the HSA contribution abilities. So on this one, we kind of concluded that it likely requires a plan amendment. Go ahead, pull out your documents again, see what they say. You are probably going to have to make an adjustment, but more important than that, you're going to need to communicate so those people know what's going on. Oops. And that is my touching something when I shouldn't have been touching there. Okay, so when we, let me get back here to the right place. There we go. After talking about telehealth, then we go and we need to talk about OTC drugs and medications. This one is not temporary. So far, many of them have been temporary. This one is not. Here we are talking about over-the-counter medications. They no longer have to have a prescription with them, which is wonderful. Many of us remember the days when an RX was not required, and then it was. So going back to that is good. But it's not only good with respect to that particular requirement. We also have clarification that reimbursement of over-the-counter medications can be made before the deductible has been met for purposes of the HDHP plan. And again, the HDHP plan and preserving that status is important because we want people to be eligible to make their HSA contributions. So we had clarification there. This means that over-the-counter medications without a prescription are now allowed for health FSAs, health reimbursement arrangements, HRAs, and HSAs, which is wonderful news. We also have a new category specifically recommended for purposes of 213D reimbursable expenses, and that's the full line of menstrual products. So that clarification is extremely welcome as well. Interestingly enough, these expenses, the over-the-counter medications no longer requiring RX, and the menstrual products are they kind of go retro because they are for expenses incurred on or after January 1, 2020. Okay, that introduces some of its own unique issues. For example, if you have a plan, a health FSA or an HRA, for example, that is not calendar year, you may actually be spanning more than one calendar year by going backwards to January 1, 2020. So you need to pull out your documents there, kind of evaluate what this wonderful news means in terms of communication and then also plan amendment. So review the plan document, review the SPD or other summary materials, review what's ever been posted or published, say on a business intranet. If you refer people out to another location, make sure that all of this is now pulled in line so that those people that are impacted by this expansion know about it and are able to take advantage of this. And I just put on the bottom as a note that it may be helpful for employers with health FSAs that have been negatively impacted by the delay in many non-urgent procedures. We've seen a lot of kind of elective surgeries and services considered non-emergency put on delay, and that may have been something that someone had expected and actually done their salary reduction under their health FSA, and they're sitting there with this money and they need to do something with it because they don't want to lose it. Well, this expansion with over-the-counter and then the menstrual products may be a way for them to not have to face the use or lose possibility. So that's another communication possibility, good news for them when they may be sitting there only having heard not so good news. Okay, so what are the ripple effects? And the ripple effects are really kind of the things that we have this law, we're getting to the point where now we know what it means, what it's going to take to comply, and that's only the beginning because these changes don't happen in a vacuum. We need to look at administrative systems. If you administer in-house, if you use an outside third party to do administration, we need to make sure that all of the pieces are working together. And unfortunately, instead of like 60 or 90 days during open enrollment for the purpose of the start of a new plan year, we don't have that because this stuff either went into place April 1 or, as we just talked about with our over-the-counter and menstrual products, it goes back to January 1. So pull these, take a look at the relationships, who's doing what, pull the plan documentation out, really focus on the communication, and don't forget retirees, people on COBRA or continuation coverage, and people who might be covered, for example, under a qualified medical child support order. Make sure that all of these people get the message. And if it's not stating the obvious, sometimes I, get on my soapbox here. We recommend using multiple means of communication, posting, intranet, for example, posting hard copy in the lunchroom, written, okay, electronic, voicemail, and good old-fashioned pick up the phone and call, phone messaging. Use multiple means, and you increase the likelihood that people are not lost in the shuffle. Okay, we're going to switch gears. And as I mentioned earlier, this is really unprecedented that we would have a situation where the federal government is saying you, employer, must provide these two types of paid leave. Now, one is kind of brand new. That's the emergency paid sick leave. Okay. And the other one is not really brand new for a lot of employers because it expands or builds upon FMLA, which has been around for a very long time. I remember when it was first issued. It was very exciting then, not quite as exciting as this, but it's been around for a long time. Now, the thing to remember here is it's expanded onto something that employers should be very familiar with unless they've never been subject to FMLA, and we're going to talk about that particular group in just a minute. Okay, emergency sick paid leave. First of all, effective April 1, so we've already been doing it, or at least subject to it. April 1, 2020, it is temporary. So it is through December 31st, 2020, so the December 31st of this calendar year. Keep that in mind. There has been significant detail provided by the Department of Labor temporary regulations. Those were the regulations issued April 1. And that was the kind of what I called earlier the real guidance. It wasn't sub-regulatory guidance. And so lots of information there, and we will be talking about a lot of that in the next portion of this, this webinar. Okay, so who is subject to this stuff? So we look at what's the definition of employer. It's very broad. Private sector employers, fewer than 500 employees. Okay, so how do you count the employees? Well, it's all employees, and we aren't using FTEs. So if you are an employee on, and you work part-time, 20 hours a week, you are not counted as half a person. You are a whole person. Right? We do need to also keep in mind that we look at the controlled group concepts. Those come from the IRS. Some of us are aware of that, particularly with respect to non-discrimination testing for our benefit programs. But it looks at if two companies are related enough through ownership or control, for example, they're going to be considered as if a single employer. Then we also have this concept of integrated employers, and that comes from FMLA. So we've got these concepts out there that require you to kind of count what may appear to be separate businesses all together as one. So why do you care about that? Well, one of the reasons you care is because if you think that you are under that 500 employee threshold, and so you offer this sick leave, and again later when we talk about the expanded FMLA, you offer this and you're thinking to yourself, okay, I don't really like having to do all this stuff, but I know that I am going to get a tax credit against my payroll taxes in the end of the day. It'll be okay. You don't want to be offering this now and finding out at tax credit time that you are actually 500 or more and therefore don't get the tax credit. So if you are, take that into account, and you may have to pull out and do some checking to see if you are part of a controlled group or integrated employer. Now, if you're a public agency, so our school districts, our cities, our counties, our towns, those kinds of public agencies, you are going to be an employer that is covered if you have at least one employee. And so there's no special rule about having, so many employees in order to be covered, or being covered only if you have fewer than 500 employees. You got an employee, you're a public agency, you're subject. Now, in both pieces of legislation, the FFCRA, FFCRA, and then also CARES Act, there was some vague reference to small plans or small employers and how they might be exempt, but that would be through regulatory action. Well, we got some regulatory action in those Department of Labor temporary regulations that were issued April 1st. It provides the details, but I want to flag for you right here, it's not what many expected. So we are going to take a brief sidestep and talk about that small employer exemption, and in part because if you thought you might be a small employer and you were holding your breath, let it go, because the way that the Department of Labor regulations set this out, it is not what you expected. It applies for both emergency sick pay and emergency FMLA, so both of these required paid programs, and it looks at employers with fewer than 50 employees. So an employer with fewer than 50 employees is exempt, sounds good so far, when imposition of the requirements would jeopardize the viability of the business as an ongoing concern. Still sounds good. I am one of those. My law firm is one of those, and I'm thinking, yes, I'm heading in the right direction here. The problem is the next line. How do I establish that I'm entitled to this small employer exemption? I have to have an authorized officer of my business determine and document that one or more of the following situations exists. That the leave requested would result in expenses and financial obligations exceeding available business revenues and would cause business to cease operating at a minimal capacity. Once we get past leave requested, I'm okay. The problem is leave requested. That means I have to be ready to go and provide these benefits, and then on what appears to be a request-by-request basis, I, as the authorized officer, have to figure out if one of these three situations exists. If one of these three situations does not exist, I have to provide the paid sick leave. So it doesn't get me out of all of this, that kind of an exemption. It's an exemption from a situation-specific type of request. The second one, the leave requested, poses substantial risk to financial health or operational capabilities of the business because of specialized skills, knowledge of the business, or responsibilities. Or the third one, there aren't sufficient workers available, willing, and qualified who will be available at the time and place needed to perform the labor or services by the employees requesting leave. And those labor or services are needed to operate at a minimal capacity. So in each of those situations, it's going to be based on the person requesting the leave and the time that at which they're requesting the leave. It's not a blanket exemption. Now, could this change? Absolutely. But right now, this is what we're dealing with. Because remember, the exemption is determined by regulatory action. It wouldn't take another piece of legislation to change this. So the exemption from having to provide the benefits in relation to a particular leave request, that's where I might have an exemption. But I'm going to have to otherwise be ready, willing, and able to provide the sick leave just like every other employer. I still need to have the programs in place. I have to create a file for each application. In other words, each request for leave, I'm going to have to document. I'm going to have to keep that with my records. I don't have to send it to anyone, thank goodness, but I do need to keep it with my records, and all of this was effective already on April 1st, 2020. So that's the small employer exemption. Now that everyone has let go their breath in case they thought they might qualify, let's return back to our emergency sick pay and finish up with that particular type of paid leave. We talked about the employers that are subject to this. Now let's talk about eligible employees. All employees, no employment duration, no hours threshold. That's extensive. But who might be excluded employees? There is a limited reference in both of the statutory authorizations here for certain excluded employees. An employer may exclude a healthcare worker or an emergency responder. Now, each of those phrases is defined in the Department of Labor temporary regulation issued April 1. There is some previous IRS guidance, and those references were a little bit different, so I want you to focus on the Department of Labor because that is real guidance as opposed to the earlier IRS guidance, which was kind of sub-regulatory guidance. And both of those definitions are actually included on the last slide of this slide deck. They're long, but they are definitely worth taking a look at. That is an exclusion that is available to an employer. The employer would have to look at how they want to use that ability. Is it going to be language in their policy, their paid sick leave policy, that just says you are excluded? Is it going to be something more on the nature of you might be excluded, but it's going to be based on who you are, what your responsibilities are, what your knowledge, skills, et cetera, and the time requested? A little bit more on the order of the small employer exemption. An employer is going to have to figure out how they want to use that ability to exclude healthcare workers and emergency responders. Okay, so what are the triggers? The trigger event is that an eligible employee may take emergency paid sick leave if unable to work, including unable to telework, because of any of the following 6 reasons. And we've got 6 reasons there. If you just read those reasons, those all came from FFCRA. They're interesting, but obviously you read through them and you can tell that there's a lot of detail, a lot of definitions missing. So this was introduced in FFCRA, and then it was significantly detailed through the Department of Labor temporary regulations. So we're going to run through each of these as they are now embellished by the Department of Labor temporary regs. First one, employee is subject to federal, state, or local quarantine or isolation order related to COVID-19. Very, very important, this includes a quarantine, isolation, containment, shelter in place, or stay at home order, sound familiar, issued by any federal, state, or local government authority. It can be an order just for a classification of citizens. It could be based on age or medical condition, and we may see that on a going forward basis. Some orders that are limited based on age or medical condition. And here's the causation element. This is available only if, but for being subject to that order, an employee would be able to perform the work otherwise allowed or permitted by the employer either at the employee's normal workplace or through telework. Okay, I get that. Big part, and the employer has work for the employee. So this is qualified or limited to situations where the employer actually has work for the employee. And as an employer, that was a very welcome relief that causation element was added there. You'll see that again as we go through these other situations. Here's category number 2. The employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Couple things here. You have to have a healthcare provider that advises the self-quarantine. This is not me saying, oh, gee, I'm uncomfortable, I might have been exposed to someone, so I am going to self-quarantine. That's not the same thing here. We are talking about there must be a healthcare provider that advises the self-quarantine. This has to be based on a healthcare provider's belief that the employee has COVID-19, the employee may have COVID-19, or the employee is particularly vulnerable to COVID-19. Okay, now, when we talk about these definitions, you can kind of get the idea that this means that there's going to have to be some sort of substantiation for an employee to be able to establish that the employee falls within a category and therefore is able to take the paid sick leave. If you're making that connection, you are absolutely on target. Causation here, that following the advice to self-quarantine prevents the employee from being able to work either at the employee's normal workplace or by telework, and the employer has work for the employee. So if the employer does not have work for the employee cannot claim paid sick leave under Category 2. So you need to break these down a little bit, and one of the easiest ways to do that, I think, is to put this into a form, an administrative form, whereby we are checking off the box, and depending upon which box gets checked off, that in turn determines the substantiation that's required. Okay, category 3 is experiencing symptoms of COVID-19 and seeking a medical diagnosis. Okay, seeking or experiencing symptoms, the symptoms that are identified in the Department of Labor temporary regulation: fever, dry cough, shortness of breath, or any other COVID-19 symptoms identified by CDC. So again, we have to have the symptoms. So there's going to have to be an attestation or a substantiation there. And then there's going to have to be something relating to seeking medical treatment. And this is interesting because the clarification was that when we're talking about accessing paid sick leave time here, we are talking about paid time that's limited to the time the employee is unable to work because the employee is taking affirmative steps to obtain a medical diagnosis. And the examples include making, waiting for, or attending an appointment for COVID-19 testing. Okay, so it's narrow, it's specific. And then the causation, again, but for the need to take paid sick leave, the employee would be able to perform work for the employer, either at the employee's normal workplace or by telework, and the employer has work for the employee. So we're getting some really good clarification, definition to these various categories. 4, the employee is caring for an individual subject to order as described under Category 1 or has been advised under Category 2. Now remember that Category number 1 is that we have a stay-at-home order, and here we have a situation where the individual is subject to that order and the employee is needed to care for that individual. Or there's the advice of a healthcare provider, this individual needs to self-quarantine and the employee is needed to care for that individual. Caring for the individual, well, how far can we go here? It's the immediate family member, person who regularly resides with the employee, or similar person where there is a relationship that creates an expectation that the employee would be a person that would provide this care. It doesn't go so broad as to include a person with whom the employee has no personal relationship. So volunteering to do this, where there's for a person, we have to be very careful about those types of situations where there is not this pre-existing relationship. Causation, again, preventing the employee from being able to work at employee's normal workplace or telework, and the employer has work for the employee. The 5th one, this is the one that overlaps to some degree with the extended FMLA. The employee is caring for a son or daughter if the school or place of care has been closed or the child care provider is unavailable due to COVID-19 precautions. This one is more broad. Son or daughter, biological, adopted, foster, step, legal ward, standing in local parentis, and under 18. Okay? If the child is 18 or older, there has to be it has to be a situation where the child is incapable of self-care because of mental or physical disability. So again, we have a fairly broad definition of who can fall within son or daughter. The reason for the leave is to the employee needs to take the paid sick leave because they're unable to work due to the need to provide care. The school or place of care is closed due to COVID-19, and no other person is available to provide the care during the time of the paid sick leave. So again, substantiation here. The causation, similar to the others, where you has to prevent the employee from performing work for the employer, either at the employee's normal workplace or by telework, and the employer has to have work for the employee. So broad, and we'll return to many of these elements in just a minute. Now, number 6 is that the employee is experiencing other substantially similar conditions specified by agencies. Currently, we don't have anything here that's available. We may have, it may be identified at any point, any day, so we need to keep our eyes open for this. But currently, we do not have substantially similar conditions that have been identified. So keep that one in your pocket. So what do you get if you've established you fall within one of the 5 categories. You get paid leave. Okay, for full-time employees, up to 80 hours paid sick leave, which is basically a 2-week period. For part-time employees, up to the paid hours you normally would have worked over a 2-week period. Okay, and when we talk about full-time, part-time, because we all know, having gone through ACA and who's full-time, who's not, that you have to look at the particular statute involved. Full-time for purposes of this program is regularly scheduled to work 40 hours or more per week. It makes sense because then that relates back up to the 2 weeks, which equals 80 hours. Part-time, again, it's going to be based on the fact that you work less than 40 hours a week, but it's going to be based on the actual hours you would normally work. Okay, then how do you value the hour? For categories or reasons 1, 2, or 3, it's the average regular rate of pay not to exceed $511 per day or $5,100 total. If it's reasons 4 or 5, we do have 6 in here, but remember 6 isn't available right now. 4, 5, and 6, it's 2/3 average regular rate of pay, not to exceed $200 per day or $2,000 total. The math, in large part, is being left up to the employer to monitor, so keep that one in mind. And when we talk about average regular rate of pay, it's basically what the employee normally gets paid for the hours worked using a 6-month look-back period. And this is specifically addressed through the Fair Labor Standards Act. So it is not a new and unique type of way of measuring or valuing these hours. Okay, other rules on the emergency paid sick leave. We've got no requirement to find a substitute. The benefits cease with the next regular work shift following no further need. Now, particularly when we're talking about you have symptoms and you're seeking, medical care, that means we may have a very short period of time, and once that period of time is done, if the appointment is on Tuesday, the next regular work shift starts Wednesday, their need for that time is probably over unless for some reason the appointment didn't take place. So keep those things in mind. There's no carryover. And anything unused does not get paid in cash. So these are separate and apart from any other sick leave programs that the employer might have in place. You cannot require use of other paid sick leave first. So we are talking about this is corona specific. You use your corona leave. If an employee wants to use it, they can. And you can require reasonable notice, but you can't necessarily require it in advance because a lot of these are kind of rolling as we go, and it would be unreasonable to require it in advance. There is the posting requirement, so hopefully those of you who are employers subject to these requirements have already posted your DLL notice on site. Okay, so let's move on to the second one, which is the second area where we have a required paid leave period, and this is the Emergency Family and Medical Leave Expansion Act. It's expanded FMLA. Now, it also was effective April 1, 2020. It is temporary through December 31st, 2020. It has a number of special terms that sort of take the place of the terms that are otherwise in an employer's FMLA policies and procedures. Okay, so they are expanded terms. They provide expanded benefits. But some of the other terms under the FMLA still apply. So, for example, when we are talking about certain types of substantiation, they still apply. And we are talking about how do you handle COBRA for group health benefits under an FMLA leave. Those rules are going to apply with respect to expanded FMLA as well. So it's kind of an intermixing of new and existing. Now, I mentioned earlier, many employers will have existing FMLA policies because there's a 50 employee threshold. If you've got 50 or more employees, in general, you're going to be subject to FMLA. You have been for over 20, for a very long time. I'm not going to say a number because I'll do my math wrong, but for a long time. You already got policies and procedures in place. this is an amendment, an addition, an expansion of what you've already got in place. The hardship falls on the smaller employers, the employers with less than 50 employees who have never been subject to FMLA, and all of a sudden they're subject to this expansion, which kind of assumes you already know what goes on with FMLA. So keep that one in mind. When we talk about employers for this expanded portion, we were talking about employers with fewer than 500 employees, just like the sick paid leave that we just finished talking about. All employees, we don't count FTEs. We look at the controlled group. We look at the integrated employer rules, and it's the same small employer exemption as for emergency paid sick leave. In other words, it's not the blanket exemption. You have to be standing there ready, willing, and able to provide this expanded leave unless the particular leave request falls within those 3 areas and can be documented by the employer. Okay, eligible employees here, there is a requirement. Not everybody is going to be eligible. It's an employee that has been employed for at least 30 calendar days. They are on the payroll, first of all, and then you look, have they been employed on the payroll for at least 30 calendar days? There is a special rule for rehires if the termination and the rehire is occurring within a certain time frame of all of this new legislation. So take a look at that if you have rehire situations. Also, if you use temporary employees from a temp agency, for example, and you tend to hire them, you are going to need to count those temp agency days in establishing that 30-day requirement. So kind of some special rules there. They're going to be based on the type of business that you have. There is no hours threshold, so if you've been using somebody, they've been on your payroll for 30 days, but maybe it's a hit or miss, 5 hours here, 2 hours here, there is no hours threshold. So each day that they are on your payroll is going to count. Now, the same exclusion available under the paid sick leave is available here, that the employer may exclude healthcare workers or emergency responders. Again, the employer who needs to determine how they're going to use, if at all, that ability to exclude. Is it blanket? Is it on a situation-by-situation based on the particular person's skills, responsibilities, et cetera? Is it based on the timing of the request? The employer needs to determine that and then reflect it in its policy regarding emergency family and medical leave expansion. What's the trigger event? Very narrow here. The eligible employee unable to work, including telework, because the eligible employee must care for his or her child under age 18 whose school or place of care has closed due to COVID-19 public health emergency. Now, it would have been really nice if at the beginning they just used the same words, but they didn't. There actually was a special rule announced in the IRS guidance, again, sub-regulatory guidance, with respect to children who were 14 years of age and over, somehow suggesting that perhaps they didn't need care. That was not included in the Department of Labor temporary regulations, which are the real guidance. So just kind of a flag for you there. Similar to the paid sick leave, the employer must have work for the employee to do. And when we talk about public health emergency, they really did kind of equate it with the same federal, state, or local authority emergency order that the paid sick leave uses. So it is going to include the same orders that were discussed for purposes of the emergency paid sick leave. So they tried to merge them together a bit here. The benefits, up to 12 weeks. Now the first 10 days, in other words, the first 2 weeks, are unpaid. The remainder of the 12 weeks is paid. It is the same 12-week overall entitlement that an employee is able to take under FMLA for all FMLA purposes. So that means if an employee already took 6 weeks of FMLA, That means for purposes of this expanded FMLA, that employee is only going to have a 6-week total available. The first 2 weeks of that 6-week would be unpaid, then we would have 4 weeks of paid. So it needs to work in conjunction with the 12 weeks that's otherwise available under the normal FMLA policy and procedure of the employer. Now, with respect to that first 10 days that's unpaid, you can substitute available paid leave for that first 10 days, just like regular FMLA allows you to do. Except in this case, we've got the emergency sick pay leave that we just talked about that may be available. And then there may be other employer paid time programs that are available, so that could be substituted. The paid leave, however, once we get to that, we get past the first 2 weeks that are unpaid, we're now in the paid leave, that is paid at 2/3 average regular rate of pay. Okay, it's not paid at 100%, it's paid at 2/3. Now, because the other third is not paid FMLA, the employee should be able to substitute other available paid leave so that taken together, the 2/3 that's paid and the 1/3 that isn't paid, they should be able to put together 100% of their average regular rate of pay. There's still some confusion about that out there, so keep your eyes open on that one. The maximum that can be paid is $200 a day, $10,000 total. Average regular rate of pay is the same definition that we used under the paid sick leave program. Generally what the employee gets for the hours worked using a 6-month look-back period, then we would take 2/3 of that. That would be the amount they would be paid. Now, just a reminder to everybody that there is status quo on health plan coverages. You cannot trigger COBRA. It has to be maintained on the same terms and conditions as if no FMLA leave was being taken. And so remember also that health plan is not just your major medical, it's also your health FSA, it's your wellness program, it's all of it, dental, vision. It's a broad definition of health plan. It's everything that would otherwise be subject to COBRA. So remember that you do not trigger COBRA. Other rules. If it's foreseeable, then the employee is required to give notice. They use the word practicable. I'm not sure what that means, and there wasn't a definition, so I'm thinking that that probably means notice does have to be provided, but everybody kind of has to work together, row the boat the same way in order to get that notice and the substantiation that goes along with it all set up. Now, there is a special rule for employers with fewer than 25 employees. This is different and separate and apart from the small employer exemption. This has to do with what happens when you come back from the FMLA. It's called the restoration requirement. And if you are an employer with fewer than 25 employees, the employee is not entitled to the same position when they come back following exhaustion of the leave if the employer has taken certain steps. And the employer's certain steps are that the employee's position when the leave started does not exist due to economic conditions or other changes in operating conditions of the employer. So the employee went out, things changed, no position. The employer makes reasonable efforts to restore the person to an equivalent position. So if there is an equivalent position, the employer, when the employee comes back from the FMLA, should be making reasonable efforts to put the employee into that position. Equivalent is in terms of benefits, pay, terms and conditions of employment. And if those reasonable efforts fail, then the employer must make reasonable efforts during the contact period to contact the employee if an equivalent position becomes available. And the contact period is defined as the earlier of the end of the public health emergency or 12 weeks after the date on which the FMLA expanded leave commenced. And it appears to be, like other exemptions, it appears to be on an employee-by-employee determination. So normally if an employee came back from an FMLA leave, they were protected. They got their job back or an equivalent pay, they got it back. There was none of this, well, sorry, you know, it doesn't exist. There were some exceptions, but the general rule was that the person came back from FMLA, they got their position back. This is a special rule for employers with fewer than 25 employees when they're coming back from this particular type of FMLA leave, the one associated with the COVID-19. Okay, ripple effects. Changes do not occur in a vacuum. Healthcare reform reporting and penalties. Keep in mind that, your 1094, 1095 reporting. Why? Because W-2 wages might be used as the basis for determining affordability of health coverage for an applicable large employer. And we know that under the FMLA, only 2/3 of the normal wages will be being paid during that 10-week, up to 10 weeks of the FMLA leave. So this could actually impact how you report for purposes of affordability on your 1094, 1095. That then begs the question, you might have other wages that or other benefits that are tied to W-2 wages. Good time to determine that because the W-2 wages are going to be less. Tracking as part of the overall 12-week maximum under FMLA. You're going to need to pull out, you know, how you track and where people are in their 12-week maximum currently, because that's going to impact how much they have available if they were to come in and request the FMLA under the special expansion. Cafeteria plan. There is no general authority to allow changes due to a wage reduction. So if you're, you know, we have to be careful about that. Now we're also going to have provisions in there about what to do during an FMLA leave. If we're talking about someone on the expanded FMLA leave, we're going to need to follow that unless we make a change. Dependent care reimbursement, we also know the irrevocable election rules are pretty broad and generous on that one. So if the care location has closed or the person is unavailable, that is going to allow a change in the cafeteria plan. Okay. Also pull out your existing paid time programs. The substitution of available paid leave for the 2 weeks of the FMLA extended leave. We need to know how to coordinate those or if they might be in play or have to be coordinated. And then also pull out your leave donation programs. Remember that leave donation programs are fairly narrow. It involves the medical emergency situation of the employee or a family member. That's it. And then we have national disasters. But COVID-19 is not a declared national disaster for purposes of a leave donation program. So in an effort to be really generous, you may get yourself into a little bit of a box. So pull these programs out, look at what they say. Paid tax leave credits, what I want to leave you with here is the idea that it's not available to state political subdivisions. However, the idea is that whatever you as an employer have paid out for emergency paid sick leave or expanded FMLA, together they're referred to as qualified leave wages, okay? You are going to be able to take that as a credit against payroll taxes that you would otherwise owe and that are reflected on the IRS Form 941, okay? In addition, you are going to be able to take credit for qualified health plan expenses and the employer's share of Medicare tax on all of the above. It's a heavy, heavy employer substantiation requirement. I know I'm running just a few minutes behind here, but I hope that you will, you've got a couple minutes extra to spend with me here. Qualified health plan expenses are kind of the new definition on the block here, and this is amounts paid or incurred by the eligible employer to provide and maintain group health plan coverage. This is during the time that someone is on paid leave, sick paid leave, or someone is on the expanded FMLA leave. Group health plan, broadly defined, includes traditional group health plans, your major medical, dental coverage, vision coverage, wellness coverage, HRA, health FSA, not HSA. But in most cases, the employee is self-funding the HSA through the cafeteria plan anyway, so there isn't really an employer, a true employer contribution there. It's amounts paid or incurred. What does this mean? Well, it means the amount that the employer is paying, like the portion of the cost of the premium for traditional group health coverage, and the amounts that are paid pre-tax by the employee through the cafeteria plan. I don't know if someone's missed that or what, but it actually does provide for that. It does not include amounts that were taxable to the employee or for which the employee paid on an after-tax basis. And when we talk about amounts that were taxable to the employee, keep in mind that if you are self-insured on a health plan, whether it's your health FSA, your HRA, your full big medical coverage, anything that is self-insured is subject to non-discrimination requirements under Section 105H. If you fail them and income is imputed to your highly compensated, you will not be able to take that amount. You will not be able to take that amount as a cost to maintain the group health plan. They do have to be properly allocated. I think, my opinion, they went into a heck of a lot of detail for something that didn't require quite that much attention. Basically, if you've got a person that's taken the paid leave and they're going to have their health coverage kept in place, we're going to be looking at the cost to keep that health coverage in place, which most of the time is going to relate down to what's the COBRA premium, what's the premium cost of the coverage. These FAQs were largely designed to not allow an employer to kind of take other expenses and just because they were paid during this period, take the full credit against payroll taxes owed. So they are protective in nature. Take a look at them, but kind of think in your mind the COBRA premium. It's a credit against payroll taxes otherwise due. Now, these are payroll taxes otherwise due for the entire employee population, not just the employees that took the leave. Okay, so it's a much bigger pool of money, basically, that the employer has to pay as payroll taxes that can be reduced by the amount of these costs associated with the paid sick leave and then also the expanded FMLA leave and the qualified health plan expenses. They're calculated on a quarterly basis. They are reflected on Form 941. The employer retains the amount of federal employment taxes otherwise due. So in other words, the employer doesn't have to send all this money to the federal government. So it's doing its own math prior to the submission. If you deposit too much, it's treated as an overpayment and you'll be refunded. If not enough payroll taxes to offset, the employer is going to be able to request an advance payment. I did include a link here with the new IRS Form 720 or 7,200. When on earth have you seen a new form come up that fast? But it is available online. Just a note for you, the way you submit it is by fax. Okay, there is no mail and there is no online submission. Here's quite a bit of information about the employer substantiation. Take a look at all of this because this is what the employer is going to need to have to do, document, and keep to substantiate the amount that it is saying I don't have to send to you, federal government, because I am taking the tax credits. It's a lot, you can imagine, because the employer is being asked to do that math itself. Calling to your attention towards the bottom, there is a general record-keeping requirement for 4 years after the date the tax becomes due or is paid, whichever is later. So if you are filing a 941 and you would for a quarter and you would otherwise have to be forwarding, X thousands of dollars, but you've taken a credit against it, you want to make sure that you have all the documentation necessary and that you are keeping it for at least 4 years from that date. I put a note box in here because all of this can be gathered as part of the request for the leave process in the first place. All the detail. For example, documentation showing how you determined the amount of the qualified leave wages. You need to substantiate that the employee was entitled to the leave. Well, all of this, if you build it in as part of your leave request process and the substantiation process for the employee to get the leave, you will have all of the, all of the minutia that you need to then determine not only what your tax credit is, but also all of the documentation and the computations to support that. So here, great one to take a look at after the close of our webinar, but it is the type of information that if you include as part of the request for the leave, you will be far and away, in better place to claim that tax credit. And the reason I stress this one is because it all started April 1, remember? I think there's a tendency to just kind of read it, give it a knee-jerk reaction. Do you get the leave? Yeah, you do. Okay, go. We'll see you in a bit. And you really don't want to treat it that way. Okay, additional recommendations. This is my ripple effect overall. Get payroll involved. 941 quarterly. I mean, we need to have payroll involved. Inventory what you have. Talked about a number of these. Just a recap. Inventory the programs you got. Determine what FFCRA and CARES Act require and what they permit as they relate to you. Are you an employer that has healthcare workers, emergency responders? Take that into account. Figure out how you're going to build that into your policy regarding paid leave, sick paid leave here, or how you're going to reflect that in your expanded FMLA policies and procedures. Reflect what you need on the substantiation and regarding substantiation information on the administrative forms. Collect it up front. Err on the side of over-collecting rather than trying to pay and chase. And then reflect the approval or denial of a requested leave with the reasons. We've actually included this on the bottom of our administrative forms for office use only down at the bottom. And we've included a place that if a request has been denied, it's right there on the bottom. You check off the box that it's been approved or denied, and if it's denied, you write out right there why. That is all necessary information that the employer needs to have. It's much easier to have it all consolidated on a single form. Adopt plain language or policy language. If it's temporary, reflect that it's temporary. If you've got collective bargaining groups, take a look at those contracts. What's out there? What are the limitations? Communicate to those affected. I think I've commented on that one enough. But also designate a person for questions. Have a person that is identified as the person to triage. You want to have a uniform and consistent message coming out regarding benefits and who's available and what has to be done. Keep all records, including any memoranda to the file for the 4 years, and as I mentioned before, including if you deny a requested leave. Keep your eyes open regarding future regulatory guidance, and actually that should be future regulatory guidance and legislative efforts, because we already know that there are additional packages being talked and argued at the federal level. They will come out at some point. Whether they will impact what we've been talking about or not, we don't know, but it may also provide an additional program. So we need to keep our eyes wide open. More to come, and keep in mind that there are some other things coming around the bend, like 5,500 filing deadlines. Keep your eyes open for that, because the CARES Act does give the Department of Labor authority to postpone compliance deadlines, and this would be one that I wouldn't be surprised for calendar plan years gets delayed out, perhaps even an automatic extension to the fall. Discussions about further legislative packages, I mentioned that one, and remember that the two areas that they tend to focus on are technical corrections for what they already passed, and then also addressing new areas of need. We'll have to see how that impacts our benefits. So with that, I think we have a couple minutes for questions, and I don't know if any have been submitted along the way. But lots of information, so thank you for sticking with me for the whole hour and 15 minutes.
Yes, Darcy, this is Mary. Thank you so much for that presentation. It is a wealth of information, but we really appreciate you taking us through it all. And yes, we have several questions that have come in through the Q&A, so I appreciate everyone's patience, as we will try to answer some of those. As time permits, we welcome you to stay on. But I wanted to just make sure everyone is aware that we will be sending out the slides to this presentation as well as a recording. to everyone via email within the next day or two, so please look for that. And we do want to open it up for questions. I believe John had one to start us off.
Yeah, actually, Mary, John Jeffrey here. Thank you, Darcy. A lot of information. Just wanted to clarify for our audience a couple of things. And so I realize, that if I'm an employer, it's almost overwhelming with regards to, all the things I have to think about. Wanted to point out a few things where we at Alerus have your back. So Darcy mentioned the change in over-the-counter medications, that's broadened, and that now is going to be eligible, for claims under an HSA, FSA situation. Actually, this morning we already notified all participants via email. We have email addresses, as you folks know, that's the primary interaction with participants in our world. And so this morning they were already notified that that is opened up and that it's opened up retroactive to the first of the year. And, if a claim was denied, they can turn around and still submit that, and we will process that. So check that box off of the many things you have to worry about. We have you covered with regards to that over-the-counter issue. Secondly, with regards to plan amendments, just want to clarify, Darcy talked about the need to amend when it comes to a self-insured health plan. Obviously that's not Alerus. That's something you would work with through your insurance carrier or with outside counsel. But we do have your back when it comes to the cafeteria plan and any amendment needed there. There too, stay tuned. Either today or early next week, you should be getting an email to all of you explaining exactly what the status is with regards to that and how we're going to implement any type of plan amendment which is going to be needed. And then finally, wanted to comment with regards to the complications that you're going to face with regards to determining whether, your employee is covered by FFCRA and how you calculate that. From our processing standpoint, it will still require the employer to make the determination that the individual meets the criteria for that paid leave. But once that occurs, if you're using our payroll services, we have the ability, at least we anticipate to have the ability, that our software will assist in doing that calculation. With all these things, keep in mind that I think I've heard it said, and I think it describes the situation of the world right now. In a sense, we're building the airplane while we're flying, right? And so this is not the normal implementation of legislation, that the industry gets to comment on for a year before it becomes effective, and to prepare, many of these things are passed and then immediately effective. So we will work closely with you to cover those administration issues. Darcy, I think you did a nice job this morning. And Mary, do we have any other questions?
Yes, John, we certainly do. And again, I want to thank everyone and encourage you to stay on if your time allows. A couple questions here. Mary did ask, are over-the-counter medications, does that include supplements, vitamin supplements?
Over-the-counner medications, I think that they can include supplements, and certainly when we could use the prescription aspect, we could get that, we could get that piece. There actually was a helpful part about a prescription with over-the-counter supplements. When we talk about over-the-counter supplements now without an RX, the question really is whether it's medically necessary or whether it is designed to improve, just generally improve good health. So what you may see with supplements and other types of things that don't raise those same questions, like a baby aspirin, for example, we may be back to our situation where we ask for a medical necessity documentation, that this is not for general health. This is for a condition. And so it's not a prescription, but it would be a medical provider's medical necessity note. And so that's how a lot of times we conducted claims verification and such prior to the actual RX requirement, and I think that's what we may end up with in certain situations. Supplements are one of those situations, whereas Benadryl or Claritin, it's a little more clear that you wouldn't be taking this for general good health. So I suspect that we might see situations where you are going to have to get a medical note that says, this is in response to a condition that this person has, not merely for general good health. I take a lot of them, and I'm going to have to deal with that issue as well.
Thank you, Darcy. Much appreciated. The next question is from Jenny. Jenny asks, if an exempt employee seeks FF-CRA, emergency sick leave, or FMLA at 2/3 rate, can we reduce their wage for the hours requested?
Okay, and I have to be really careful on the exempt, non-exempt, because my box ends when it starts going over into kind of employment law. So so kind of take this with a grain of salt. What happens is you would determine what their hourly, what an hourly equivalent rate would be based, for example, on the fact that they are not subject to the overtime minimum wage requirement, so that they're exempt. It's very clear in all of the sub-regulatory guidance and also the real guidance, the Department of Labor temporary regs, that dealing with, for example, a salaried employee, you actually are able to go in and come up with an hourly value. And so then if you can come up with an hourly value, then it operates the same way as under FMLA, where you don't have to be looking at a whole day. You can use parts of days. There actually is a lot of background in the FMLA regs themselves about how to deal with salaried employees and intermittent leaves, and then also partial day types of leaves. That would be my suggestion, to look there first and then work backwards to how those regulations under FMLA allow you to work under the paid sick leave and also the expansion of the FMLA. So sorry, it's not an answer, but it's a helping you to get to the right place to get your answer.
Oh, that's great, Darcy. Thank you so much. A question from Bryce. Can you touch on public employers, such as the school district?
Sure.
Okay,
is that just what it is?
So
okay.
I have a specific
okay,
question for you.
Good.
So an hourly school staff that no longer is working, would they qualify for paid sick leave or expanded FMLA when schools are still operational and that teachers are still remote teaching?
Okay. Remember, we've got the two places. We've got the paid sick leave for the 6 categories that are really 5 right now, and so all of those, remember, have a causation that the employer has to have work for the employee to do. So the employee has been furloughed, or there is no work for that employee to do. They're not going to be able they're not going to be able to take advantage of the sick paid leave provisions. When we talk about the expanded FMLA for the school being closed, the child care provider not being available, again, when we work through those elements, there is still a requirement that the employer has work available. So if we're, if you're dealing with a teacher that is teleworking, that's very different, for example, than a cafeteria plan worker or a janitor that is not working, where, in other words, cuts have been made or layoffs or furloughs, and there is no work for that person to do. So it's not as simple as just saying schools. We actually have to go in and look at the particular positions within that school. What is, is there work that the employer has for them to do? I kind of use that as my litmus test going in right away. Is there work? Because if there isn't work, we don't even go through the next, all the substantiation issues. And I'm not sure if I'm getting to exactly what his question was, but the schools are a little bit different because we do have a lot of telework that is happening, particularly with administrative staff and then also teachers that are teaching, online. But certainly not all school employees are going to be able to take advantage of the paid sick leave or the expanded FMLA.
Excellent. Thank you, Darcy, for that. Next question is from Rosie. For emergency paid sick leave, what if the employee's spouse is a high risk but not necessarily being told to quarantine? Would the employee qualify for emergency paid sick leave to care for that person?
Okay, that's a great question. And before we had the Department of Labor temporary reg, it was sort of like, wow, it seems to make sense, but what do we do? And actually, if we go back into our categories, we would need to go to category 4, and that actually is on slide 24, just kind of for that person's reference. When they get the slide deck, look at slide 24, and that is the one where the employee is caring for the individual, but it bounces back to the individual has to be either covered under the order, federal, state, or local quarantine or isolation order, or that individual has been advised by the healthcare provider to self-quarantine due to concerns. So one of those concerns, the healthcare provider's belief, is that the employee is particularly vulnerable to COVID-19. So there isn't really anything here that's going to get to the high-risk spouse under the emergency paid sick leave. I'm just kind of running through those to care for, unless we do have the employee's individual is someone, well, you know what? I think it would be number 2. Sorry, I'm doing this on the fly. I would go under category number 2, because if we're talking about the employee's spouse, then we would substitute in the employee's spouse for the employee under category 2. And if that employee's spouse has been advised by a healthcare provider to self-quarantine, and that would mean the healthcare provider's belief that the spouse is particularly vulnerable. So I would work with the healthcare provider for the spouse and get that healthcare provider to put, into writing that this person is particularly vulnerable to COVID-19 and that the healthcare provider recommends self-quarantine. That then would allow the employee under category 4 to request the paid sick leave. Excellent question.
Great. Thank you, Darcy, for that explanation. Very helpful. And
I'm going to use that one. I'm going to use that one as an example. Yes, excellent.
I would love to ask 1 or 2 more questions as we are coming to the end of our time here, but want to get another one in for you. Tracy asked, we have an employee who is engaged and whose fiance's daughter needs care. They do live together, and the fiance's daughter has special needs and is in quarantine until the state of emergency is lifted. This is not our employee's child. So the question is, does the employee still qualify for the FMLA?
Okay, and that's going to come in under our that's going to come in under our definition of son or daughter. Under the paid sick leave, that's Category 5, and then also under the expanded FMLA, that's looking at the child. And when we look at that definition, it is broad. However, it is, I would be very surprised if it is broad enough to cover that situation, because the one possibility would be standing in loco parentis, which is a Latin term, but this is not what that term is supposed to be getting at. They live together, so we don't have the adopted or the foster or the step. I'm assuming that they probably do not have anything that creates the fiancé as the child as the legal ward of the fiancé. That is really a tough one, but I don't think that the definitions go far enough to allow that particular employee to stay home and care for the special needs child of the fiancé, even though they do live together.
Okay, thank you, Darcy.
I'm not seeing it. Sorry.
Okay. No, that's okay. Thank you. Appreciate your honest answer and your transparency. So I had another question from Jenny. Can employees and essential businesses use the governor's shelter-in-place order as a trigger for emergency paid sick leave if we have work available?
Okay. Can you just reread that first part of it? The essential?
Sure. Can employees and essential businesses use the governor's? Okay.
Okay. So what we have are essential businesses, and the essential businesses are the businesses that are allowed, even though there is a stay-at-home order by the governor, essential businesses are allowed to continue operating. Now, they may be operating all or in part remotely, but I know that my law firm, for example, is considered an essential business, even though a lot of people would question why lawyers would be essential. But we have people that are working remotely. We also have people that are working at the office. So an essential business means that you can still operate like that. So once you get to that point, now you have a situation where if it's almost the classic example of this is where the sick paid leave and the FMLA really come into play, because I, as an employer, have somebody here at the office who now has a situation that would qualify them for sick paid leave. And obviously, if they're here at the office working for me, or they're at home teleworking, I have work for them to do, which is a requirement in order to request paid leave. So I think this question actually gets at essential businesses are really at the center of what the sick paid leave and the expanded FMLA provisions were focused on. Because if your business is ongoing, you are an essential business, you are open, you have work, by definition almost, you have work for people to do. That is precisely where you're going to have employees that if they meet the definition of eligible employee and they have one of the situations that is described that entitles them to take paid leave, they're going to be able to request and take that paid leave. Now, good news, bad news. Bad news, you're going to be, without the benefit of that employee while they're doing this. But the good news is then you will be able to take a credit for the amount that you are paying them for the paid leave. You will be able to take that credit against the payroll taxes you would otherwise owe for that next quarter. So you're going to need to let them go take this paid leave, but it's actually not going to be $1 out of your pocket. It's going to be the fact that you are now without an employee that you thought you were going to have. But that's a good question.
Great. Thank you, Darcy. Much appreciated. And I would just like to say that the wealth of information that you've covered, extensive, and we appreciate that. There are still some questions that unfortunately we do not have time for as we need to wrap up today's webinar. But I do want to say again that we will be providing a copy of the presentation slides, a copy of the recording to everyone via email, and we do have those questions captured, and I will extend that on to John and his team to be able to do some follow-up. Or you can always reach out to your Alerus representative if you have specific questions that you would like to ask. Again, I want to say thank you to John, thank you to Darcy, and thank you to all of you for attending today's presentation. We will sign off for now. Thank you and have a great day.